Okay, this is part 2 of the motion in limine number 2. This is from the Wayfarer parties, of course, to preclude evidence of alleged weight-related comments. In evidence concerning plaintiff's allegation that Baldoni made comments about her weight is irrelevant, unduly prejudicial, and constitutes improper character evidence, and therefore should be excluded under federal rules of evidence 401, 402, 403, and 404. This action concerns an alleged smear campaign the defendants launched in retaliation for Lively's complaint of misconduct. On the set of It Ends With Us, Baldoni's alleged inquiries to Miss Lively's trainer about her weight and are collateral to the issues to be tried and would not make any fact of consequence more or less probable. Therefore, comments about Lively's weight are irrelevant under Rule 401 and inadmissible under Rule 402. Excluding allegations that risked turning the trial into a multi-ringed sideshow of mini-trials on collateral issues pertaining to the conduct and relationships of third parties that may have only been tangential that bearing, if at all, to the issues and claims disputed in this case. Even if marginal relevance could be established, any probative value is substantially outweighed by the risk of unfair prejudice, jury confusion, and misleading the jury. Introduction of alleged weight-related comments would invite the jury to base its decision on emotional or moral judgment rather than the evidence directly related to the alleged harassment and retaliation. Permitting such testimony would improperly shift the focus from the veracity of the plaintiff's causes of action to inflammatory, unrelated assertions that could unfairly prejudice him in violation of Rule 403. Furthermore, such testimony constitutes impermissible character or propensity evidence under Rule 404. Alleged comments about weight would be offered solely to portray Baldoni in negative light or suggest a propensity to engage in inappropriate behavior or conduct that made Lively uncomfortable but does not fall within the purview of the sexual harassment statutes. They are not offered for any permissible purpose under Rule 404, such as motive, intent, or knowledge, and thus constitute improper character evidence and would unfairly bias the jury. For these reasons, any testimony or evidence regarding alleged comments about plaintiff's weight should be excluded in their entirety. Motion in limine number 3, to preclude evidence concerned alleged sexual assault. Yeah, because there was no sexual assault. Like, this is ridiculous. Lively may attempt to introduce evidence concerning her claim that Baldoni admitted to sexually assaulting other unspecified women. Defendants respectfully submit that Baldoni never made any such admissions and never engaged in such conduct. Regardless, Lively's inflammatory evidence should be excluded under federal rules of evidence 401, 402, and 403. Any sexual harassment that Lively may seek to prove in this case pales in comparison to allegations of sexual assault. Evidence shall be excluded as unfairly prejudicial when it is more inflammatory than the charged crime. Overturning a criminal conviction where evidence was significantly more sensational and disturbing than the charged crimes. For these reasons, evidence related to sexual assault should be excluded here. Yeah, because I totally agree. Motion in limine number 4, to preclude all references to other clients of Melissa Nathan and Jed Wallace. Yes! Finally, because Rebel Wilson, what the heck? Like, she has no bearing in this freaking case. Lively's exhibit list includes many emails and text messages referencing clients of Melissa Nathan and non-party Jed Wallace. Again, non-party. Jed Wallace and their companies, which have no relationship to Lively or this lawsuit. These exhibits fall into 2 great general categories. 1, communications exclusively referencing other clients of Nathan or Wallace, not Wayfarer Studios, or the services rendered for those other clients. And number 2, communications referencing services for Wayfarer Studios and other clients, such as internal tag text chain referencing Baldoni and Lively situation, and separately services that TAG has performed or will perform for other TAG clients. Pursuant to Rules 402 and 403, the court should preclude these exhibits as well as any references to representation of or services rendered for other non-party clients, because such evidence is not relevant to the matter before this court, and any reference here thereto would be unfairly prejudicial to the Wayfarer parties. And it gives an example in MF Global Holdings Ltd versus PricewaterhouseCoopers LLC. The administrator of the Chapter 11 liquidation plan for financial firm MF Global commenced an action against MF Global's outside auditor and accountant PricewaterhouseCoopers, alleging that PwC committed professional malpractice in connection with certain transactions that resulted in the financial firm's collapse. PwC moved to preclude any evidence or argument referring to other accounting firms or clients or to past accounting scandals, contending that such evidence was irrelevant and would be unduly prejudicial. The court granted the motion, holding that references to well-known historical accounting scandals, while marginally relevant to explain the historical context of MF Global's ratings downgrades or certain regulations promulgated in their wake, would be unduly prejudicial to PwC. The same result is warranted here. Any services that Nathan rendered for actor Johnny Depp in connection to his high-profile defamation litigation against ex-wife Amber Heard, for other celebrities such as rappers Drake and Travis Scott, professional wrestler Logan Paul, and actress Rebel Wilson, for politicians, or for other clients are irrelevant to whether she aided and abetted the purported smear campaign at issue herein, as alleged by Lively. Indeed, any references to Nathan's involvement with so-called smear websites are irrelevant and prejudicial because Lively does not allege that such mechanism was utilized by any of the defendants against her. Exactly. That's what we've been saying, yo. The sole reason why Lively improperly seeks to introduce evidence of work that Nathan purportedly, is that right? I hope I'm saying it again. Right. If not, tell me how to freaking say this. Purportedly? I don't know. Performed for her other clients other than Wayfarer Studios is to convince the jury that Nathan is immoral and a wrongdoer. And then another example, see Highland Capital Management LP versus Schneider. Precluding evidence that defendants committed a securities law violation because the only apparent reason for such trial strategy would be to show the jury that defendants are bad people. And then another example, Empire Gas Corp versus American AM Bakeries Co. Finding that testimony showing that party, its executives, and its lawyers were bad people was prejudicial, confusing, and misleading were principal issue for jury to decide whether there was a breach of contract. Although this court previously determined on a discovery motion that the identities of clients of Jet Wallace street relations are relevant because they could lead to information bearing on the issue in this case, the court also recognized that information within the scope of Rule 26 need not be admissible in evidence to be discoverable. Docket 390 at 2 and 1, quoting Rule 26b1. The court further noted that it need not address at the time whether the names of street relations clients or evidence of street relations other business dealings would be admissible at trial. Thereafter, the court dismissed Lively's claims against Jed Wallace and street relations, docket 912. Go Jed, go Jed. Whoa, you're dismissed. Whatever work Wallace or street relations performed for clients other than Wayfarer Studios is not relevant to the claims herein against Wayfarer parties, especially because the second amended complaint alleges that Wallace and street relations' so-called role in the... We're going to have to stop here. Follow for part 3.